Honorable Chair. Thank you.
Thank you, Commissioner.
Thank you very much, Honorable Attorney General. Judge, did you say that there's no survey which will be done to show zero corruption?
I can bet to my last penny there will be no survey whereby you go to a court in Nakuru, zero corruption, you go to Kisumu, zero corruption, you come to the Court of Appeal, zero corruption, and we come here and say, JSC, hallelujah, there is zero corruption in the judiciary. It will never.
Okay. That's a bit sad because I was hoping maybe even if it takes a few years, we could one day say that. But thank you, Judge. I'll now call upon Honorable Gishohi to ask his questions. Commissioner.
Thank you, Chair. Judge, good morning again.
Good morning, Commissioner.
Now, I want us to focus on the role of a state officer. And I'm sure you are aware that as a judge of the Supreme Court, you are a state officer and you are bound by Article 10 of that Constitution as the national values and principles of governance. National values and principles of governance that bind all state officers. Would you pick two of those principles and share with the Commission how you are going to promote them as a judge of the Supreme Court? Just two of those principles under Article 10 specifically. Two.
Okay, the first one will be to ensure that public interest prevails as opposed to your personal interest. So the position of a judge is one of trust, as the Commissioner IG has said. When you are given this responsibility, your duty is to serve, not to serve the Wananchi, not to enrich yourself because you are there.
Let's focus, Judge, yes, to Article 10 specifically. Yes. If we look at that article, those principles of governance are very, very clear. And I can give you an example. One of it is patriotism,
yes,
national unity.
Yes.
Just share with us how you promote those national values and principles as a state officer, as a judge of the Supreme Court.
Okay, because most of them now are enhanced in the Code of Conduct, they are enhanced in the Leadership and Integrity Act, but let us come to patriotism.
Patriotism, yes.
Yes. So as a judge, you have to be patriotic. You sing the National Assembly, you sow allegiance to the Constitution and promise to do what you are supposed to do. That aspect of patriotism is paramount because you have now to know that Kenya comes first as a country and not you as an individual. You have to serve the Wananchi. Kenya means the people of Kenya, what they expect of you. And the patriotism comes in many aspects. If I'm there and I'm not working, yet I've been told to serve the Wananchi, am I patriotic? I am not. So it means I have to work hard and meet the expectations of the Wananchi. Another aspect of patriotism comes in the work we do. If there is any dispute between Kenya and any other country, we have to be objective and see what are the interests of the country.
Okay.
Yes.
Let us reflect on that ruling you had for Lamu.
Yes.
About the curfew and all those other issues.
Yes.
What did you say about that in that spirit of patriotism as per Article 10, without prejudice to whatever you say?
I understand you. You know, patriotism also means that you have also to respect the rights of the Kenyans. I was living in Malindi. People were traveling from Malindi to Lamu. If you reach in Peketone at 6, you are stopped. You have to sleep in the bus. There is no imminent danger. The danger had already been dealt with. So when it comes to patriotism, here it's true, the Minister for Internal Affairs has declared a curfew from 6 to 6. The law, it provides for a certain duration, so it has been enhanced. After the period expires, it is enhanced. There is no public participation to say, you people, are you happy or what? They are complaining every day. They are complaining. So with patriotism, we feel that I am not going to be patriotic just to be with the government and say, you people, even if you are dying of hunger, just stay inside because we want to fight terrorism. No, patriotism comes in. These Kenyans need to work and earn a living. So let you can have security even without the curfew, because you can put the security personnel in the streets. Yes.
Okay, that's enough. We go to something else. As you go to the Supreme Court, I'm sure there are committees that you might be heading or you might be a member, and there will be public finance that will be a field to you. In terms of Article 201 on management of public finance, there are two items there as you manage public finance. One is financial management shall be responsible with the physical reporting regularly. As a chair of one of those committees in the Supreme Court, what is your understanding of that statement under that Article 201? Financial management, responsible use of the money.
Thank you, Commissioner. If I'm to be a chair of a committee, maybe I don't know. I have not been there to know what committees are there. Maybe human resource or finance or any other committee. It tells the use of money. The money we utilize is from taxes of Kenyans. So as we use it, the record has to be there how it has been used, and a report has to be made each financial year. If per diems were paid, who was paid and for what purpose. If somebody was sent out of the country and was given some imprest, how did he deal with that? If we are procuring, like maybe some judges need vehicles, it will go through the CRJ, but maybe the committee will deliberate. Do you just say, because I'm in the Supreme Court, I need a V8 instead of the ordinary car? So there should be that responsibility that you are not here to enrich yourself or to make yourself so comfortable to the expense of the taxpayers. And in other words, accountability. You have to account for the funds you have been given, and proper utilization of resources is a requirement.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. It's now the turn for Commissioner Koskei to ask his questions. Commissioner.
Thank you, Chair. Good morning, Judge.
Good morning, Commissioner.
Yes, I have two questions, and one is on Supreme Court and the advantage is that you are an insider in judiciary. So looking at Supreme Court as it is now, what new things do you think needs to be introduced so that it can serve this nation efficiently and effectively? People talk about issues of structure. Can it be expanded? Can it be transformed to approach its function in different ways? To you, as an incoming Supreme Court judge, what do you think are new things that needs to be introduced for it to serve this country better?
Thank you, Commissioner. In form of numbers, I think the numbers are sufficient because the law allows them to sit in a batch of 7. In form of competencies, I think the requirement is is enough, so that you are not told if you put it at 20 years, people will say you want to exclude others. What needs to be done? I think I can't say it's 100% perfect. I think this is just my view, how you think can be done. Okay, in my personal view, I think if a judge is appointed to the Supreme Court, a maximum of 15 years should be sufficient, so that we can clear you. I know other jurisdiction you are judged for life in the Supreme Court, but I think we should be alive to the fact that if I'm there and I have a specific stand on something for 20 years, for 30 years, I'm there as a judge of the Supreme Court. I think we need to look into this aspect of being there for 25 years. A High Court judge, it's understandable, but I think we should come up with an idea of a maximum of 15 years. In any case, when you go there, you are 50 plus, 15 years would be 65, which means the minimum retirement, the voluntary retirement of a judge. So maybe JSC can look at that, so that I'm not appointed at 54. I go there, I block others from coming. I'm just there. This election petition come. My policy is the same. No election petition should be allowed. I dismiss another. So you hear around 20 election petitions, and even those coming to you now fear that the same way people were fearing going to the Court of Appeal will be the same issue, because a judge has sat there, and we know his philosophy. At least there should be that change of ideas, change of personnel. I think that will be my view.
Any other? Or that is what comes on top of your head now?
Any other? Maybe we have been talking of individual judgments, because the work there is not much. Maybe when it comes into the same issue of a matter of public importance, we might want to know what is the view of each and every judge. Maybe we can come up with the rules. As long as the court says this is a matter of public importance, you can discuss, but let each and every one of you come with his own judgment, and we can zero it even to election petition that each one of you should write. You can conference, and each one of you write his own or her own judgment, so that we can know the views of each and every judge.
Thank you, Judge. My second question is, you've heard this saying, necessity is the mother of invention. Now, let us talk about COVID-19 pandemic and judiciary. What challenges has this pandemic brought into judiciary operations, and what are the opportunities that has this pandemic availed to transform the way judiciary operates? Could you give us perhaps 2-3 challenges and also opportunities that you see this pandemic has availed to this country?
Starting with challenges, Commissioner, judiciary all along, it's an interpersonal aspect of decision making. A witness comes, he talks. As he talks, I can make an impression. Is he telling me the truth, or is to some extent lying, or is not so sure? So that aspect of open court has been affected. So that is one challenge. Another challenge is also judiciary does not operate on its own. There are other criminal justice sectors like the prison. I remember when I was in Marsabit, the head of prison get instructions from Nairobi that no prisoner should go to court. So what do? This is a person who has been charged with murder, is at the police station. He cannot be taken to the prison because the prison is not admitting anybody for fear of spreading COVID in prison, for good reason. But now the police station cannot feed this person. He has been brought all the way from North Hall, which is over 300 kilometers from Marsabit. The relatives are not there. Who buys them food? So those are the challenges which COVID has brought in. Then this challenge also has generated into creating backlog. Cases are not being heard. Most of the judges are in their 50s. We are told whoever is 58 and above can work from home. We have people with pre-existing conditions. They cannot come because the fear of getting COVID, and it's real. Courts have been closed because staff have COVID, and for you not to spread it further, you close the court. Commissioner here has done good work because there is no alternative. You have to close the court. So those are the challenges which COVID-19 has brought. And what has been the avenue, we have seen an opportunity to improve our connectivity and internet connectivity, and the use of technology has really come in handy. There is the challenge of finances because we were not prepared. The system had to be upgraded. It's a challenge also, though it's an opportunity, but it's a challenge. If you log in at Milimani at 9 and all the judges are using the system, there'll be ups and downs. Sometimes you can't hear the other person on the other end, but it has served. So far it has served. In my view, it's an opportunity also to hear matters which do not need physical attendance, like appeals. An appeal is filed, the record of appeal is filed, you are not taking any new evidence. You can hear these appeals online, especially those ones where there are advocates involved. At Milimani, there's been a very good device, which I like it for those who don't have lawyers. If you don't have an advocate, there is a place where you can go there, you are connected, your case is there, you are representing yourself, you are logged in, and I can see him that this is so and so who has come for his case, and then he can talk and he has that comfort of the staff. So I think we have also tried to assist Kenyans despite the challenges we have.
Thank you. Yeah, my final question is on involvement in community service. The other time we discussed, and you told us that you involve a lot in schools, mentorship, and many other things. But when I was going through your CV again, I realized that you are doing PhD in Peace and Conflict Studies in Masinde Muliro University, and you are currently writing a proposal on radicalization. What have you in any way tried to, work with the community to see into it that this radicalization is sorted, especially in Kwale, where you come from, and Mombasa, as community service?
Thank you, Commissioner. Actually, I've passed the proposal stage. I've submitted my findings, and now they are with the external examiner. So I'm waiting for the feedback. Then I do the second defense, and I will be ready to graduate, God willing, the course of the year. Community service is an important aspect, and it's good you have raised that issue. I come from Kwale, and with radicalization community service, you have to do it in a very indirect way through empowering the youth and also through education. Kwale is one of the most affected counties when it comes to radicalization. Why I picked that topic, there are many returnees from Somalia in the county, very many. These are people who are trained. There are people who can't build a house in their rural home because for fear of being attacked by the returnees who feel that they are being haunted. Coming back to the question of community involvement, I've engaged the leaders in that area, the MCAs, to try to talk to them. During my research, I attended several meetings, one of them being preparation. Each county is supposed to come up with a county action plan to fight radicalization. So I remember being invited to go and being a participant and talk about radicalization in the sense that we have to how to eliminate it, because it's deep-rooted and you cannot just like corruption say there is no radicalization. This is somebody with his own ideology. So I have participated in trying to fight this menace. I've talked to several NGOs. There are so many NGOs in Kwale and Mombasa which deal with this aspect. Mohori, there is Aki Africa, who have done very commendable work. And I have engaged the ATPU in Mombasa, not in Nairobi. They have good intentions, trying to talk to the Wananchi coming. I've talked to the religious leaders, trying to see how they, even there is that fear. I've been talking to Qadis who are judicial officers, and they are saying, Saidi, if I go to the mosque and talk about radicalization, I'll be killed. But I've tried to talk to them and say, you don't have to denounce it publicly, but where you can, and you can go and talk to family members that there is suspicion so and so is engaged in this thing, can you talk to him? And they have understood me. So it's a dangerous aspect where village men, in fact, in that meeting where I attended, the county commissioner told me nobody is coming forward in some areas to be a Nyumba Kumi elder. Nobody. It's there, but nobody is coming forward for fear of being eliminated. So I've tried my level best, and I've understood the problem. So the prison is doing very good work trying to reform them. But now you can go to certain extent. If you poke your nose so much, you can also be eliminated.
Yeah. Yes. Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Honorable Judge, out of interest, what methodology are you using to collect data? Is it qualitative or quantitative? Yes.
I have structured questionnaires. Some are in English, some are in Kiswahili. Because of maybe I've been targeting the imams and the religious leaders and the community, then there are those educated ones, the NGOs and whatever. So that is one aspect of data collection. I have also interpersonal interviews, which I've done at ATPU, I've done at the prison, I've done with the CEOs of some human rights groups. Those are the main. The other aspect of maybe secondary material reading is also there, but I've been using questionnaires and personal interviews.
Good, and also maybe focused group discussions.
Yes. I had about 3 focus. I had a focus group at the Mombasa Law Court twice, with Judge Ogola and about 6 other magistrates and a few legal staff. I got the permission from the chief registrar to go and collect the data. In fact, I had 3. I had another one at Shanzu Law Courts and another one at the Kadis Court. In fact, the Kadis Court, it was an open, their conditions, at least 8 people. So I was there with the Kadis, 3 Kadis and the staff there, and I had another focus groups with the community. The community, yes. FDG, you call them FDGs.
Okay, thank you very much, Judge. Commissioner Onrada, it's your turn to please ask questions.
Thank you very much, Chair. Judge, there is a statement you made earlier that is making me rather uncomfortable. I just want to be clear. The Chair also revisited it and you still maintained your position concerning corruption. You said that there can never be a day where we will be zero rated for corruption. And I'm thinking it is important because there are people out there listening to you, and you are a person who speaks with authority when you speak about the judiciary. It is important to draw the distinction. Are you talking about corruption generally, or are you talking about the perception of corruption?
Thank you, Commissioner. Maybe I misunderstood. I'm not saying that the judiciary staff will be corrupt until Jesus comes. No, that is not what I'm saying. What I'm saying is, when the survey is done, it covers both it mainly covers perception that, because this is somebody's opinion. What do you think about the judiciary? Is it corrupt or it's clean? So what I'm saying is, there will not come a time when you can go around, because this is a survey, you won't ask all the Kenyans, but you're asking people mainly who have interacted with the judiciary, that can you 100% say the judiciary is zero corrupt? So it's somebody's perception. So what I'm saying is, it is very unlikely that in our lifetime there will come a time when a survey will be done and the perception, or whether perception or conceived real, because you are telling somebody who lost a case, he could have lost maybe genuinely, but to him there was corruption. So I'm not foreseeing a situation where the percentages as per Transparency International will come to zero, and mainly perception, because here we are talking about somebody who lost his file in the registry, somebody whose case took 10 years to be determined. To him it's corruption. Somebody who had paid cash bail and it took him 2 months to be refunded. He thought that maybe people were asking for him to give kitu kidogo so that he can be paid. To him it's corruption. A title deed maybe was misplaced. He has been waiting for it to be released. To him, if you ask him, he says, these people are corrupt. I've been waiting for my title deed. So unless now we are efficient to the extent that a case is filed today and in 2-3 months it has been dispensed with, that will now reduce that. It won't even eliminate to zero, but that will drastically make us like judiciary. If corruption index is done, we will be at the bottom. I don't know whether there is anybody with zero, any government institution with zero as of now, ever since the surveys have been done. And it's also the nature of our work. So to answer your question, it's the perception.
Thank you. I think I'm glad that is clarified, because I have also looked at some of the surveys that have been done for specific courts, and we do have courts that have zero, that are rated, and I'm hopeful one day even the institution will get to a point where even with the perception, we are rated at zero. Okay, well, now moving on to the questions that I had for you. I want to read from Article 27 of the Constitution, Article 27, sub-Article 3. Article 27 is basically about equality, and it says women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. And then Article 24, sub-Article 4. The provisions of this chapter on equality shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadhi's courts, to persons who profess the Muslim religion in matters relating to personal status, marriage, divorce, and inheritance. So in one respect, the Constitution is talking about equality between men and women, and then in another, it is qualified. Why do you think this qualification is necessary? And do you think then, because of that qualification, the Constitution fails to protect certain sections, especially women, from discrimination?
Thank you, Commissioner. To me, the Constitution is properly well intended, and I cannot fault it. And it's also an acknowledgement of diversity. Many people have that feeling that Muslim women are being discriminated, although I've never seen any Muslim woman protesting that she's being discriminated. Why did the Constitution come in with this? It's like a proviso to a qualification of the equal treatment. Personal status of a Muslim. There is inheritance. It's provided for in the Quran that if I die, my daughter will get 1 share while my son has 2. It's cast in stone. There is nobody who can come and say we want to change it. It has been there for the last 1,400 plus years. So it's the constitutional provision is a realization that whatever we put in the Constitution, we cannot say that it is possible to people, if they come and agree that I've seen it, even in my own family, that we want to share equally. If you agree, that provision will allow you. It's not that, although it's cast in stone when it comes to decision making, if people are disagreeing, but if you agree that let my sister get 1 acre of land and I get 1, you are not going contrary to the religion. So that is one aspect of the qualification, that when it comes to inheritance, and apart from the daughter, even the widow, the share is already provided for. The widower, the share is already provided for. If there are no children who should inherit, it's already provided for. So acknowledging that personal aspect of the Muslim was quite crucial, because it also has a historical perspective. When the state of Kenya was being negotiated, the Muslim community had to be assured that their faith and their personal status will be protected. Then there is the aspect of marriage. If you put in the Constitution that nobody is allowed to marry more than 1 wife, you are infringing on the rights of the Muslims who have the leeway to marry up to 4. I know now we have the Marriage Act, but I think that was a realization that we are a diverse community. So to me, it's not discriminatory, and there is equal treatment in line with the religion.
Thank you very much, Judge, for your opinion. It's your opinion I wanted, and thank you very much for that. Okay, my other question, it is provided in the Judicial Service Code of Conduct that a judge shall disqualify himself or herself in any proceedings in which his or her impartiality might reasonably be questioned. Give 3 instances in which a judge's impartiality may reasonably be questioned.
It comes in many forms. I'll give, for instance, I'm in the Court of Appeal, and the same dispute came before me. Maybe I may not have rendered a decision. I may have in one way or another given some orders in that file, not rendered the final decision. So a party might ask, can you disqualify yourself, Judge? I remember appearing before you. So that is one aspect. Another aspect is maybe the party before you is a relative. You might think that the litigants don't know, but they can say, we have done our research and you are related to the wife of the plaintiff. So you have to disqualify yourself. Then the other forms, maybe you are a member of a certain club which has a case before you. I remember reading I think this is the Pinochet case of the UK, where one of the judges was a member of Amnesty International, which was a party to the case, and the judges had rendered their judgment, but they have had to vacate it because of that. So that personal interrelationship with the litigant, even if it's remote, it calls for recusal, because we say justice must not only be done, but must be seen to be done. So where there is that aspect of not being impartial, then you are called upon to recuse yourself. There are many forms. Maybe it's something which you have dealt with as an advocate. You are an advocate, you acted for a company, and this company has a case before the court. You already have some views on that cooperation. You'd rather recuse yourself. And to me, recusal is a good aspect of trying to checkmate the judges and judicial officer. Why should you insist on sitting on a matter where somebody thinks that you should not? There is a difficulty when you are benches, when you sit in benches, you don't make that personal decision. It's made by discussions with the bench, as you saw in the case of Rai, where Justice Tunoi had disqualified himself in the Court of Appeal without any application. But when it came to the Court of Appeal, the Supreme Court, the same request was made, and the bench said, no, because of the doctrine of necessity, we are not allowing you to disqualify yourself. So that is another way of handling the matter, but I think I've given you the parameters. Yes.
Yes, you have, Judge. Thank you. My other question concerns Article 258 of the Constitution, which gives citizens wide-reaching rights and powers to challenge any action that is in contravention of the Constitution. Do you think this right is absolute? And if so, why?
Given to the citizen,
yes,
to challenge. I can say, since it's already provided in the Constitution, it's absolute, but it should not be abused so that you challenge each and every aspect made. But it is crucial so that there are those who cannot. I think also it's in line with that code, is it 22, which allows anybody to file a petition where there is threat of infringement of constitutional rights. I say it's a crucial provision because it widens up the right to access the court to anybody who feels that although this person's rights are being violated, he is a weakling, he may not have the capacity to go to court, let me go to court. I know it can be abused by people who are not interested in the matter other than seeking publicity, but I would say it is important to have it.
Now that you say that it can be abused, do you think then there ought to be limitations to that right?
It will all depend on how somebody will interpret it. If you put, okay, it's a right which can be limited, like you have come and pleaded before me that so-and-so is being held incommunicado without getting in touch with his members of the family, but the members of the family are saying we didn't tell this man to come to court. You just strike out the matter. So limitations can be there, but not preconceived limitations that before you file this matter, because if we put those limitations beforehand, we will be clawing back those rights. So the limitations should be in form of assessment now by the judicial officer, so that you say, although you have come to court, I can't ask you what is your interest. You are saying there is a threat of right being infringed, but I'm not seeing any threat, and you render yourself like that. But I'm not of the view that we put specific qualification that before any person files a petition relating to rights, he should have such and such interest, something like that.
Okay, thank you, Judge. And finally, what is one truth that you believe in that most people disagree with?
I don't know whether that one can have a specific, because I don't know what, even if we zero in into this room, I don't know what you commissioners believe in. But one truth I believe in the fairness of everybody. That everybody is fair. Maybe you may not believe in that, but I believe all human nature is meant to be good, unless now it exhibits itself in the opposite direction. So there are those who don't. I trust everybody, unless now you make me distrust you. I have that aspect of I meet you the first time. We have never met. I don't have to doubt you. So that is my nature. But as we interact, then I will now see whether you are trustworthy or I should rely on you. So that is, I don't. It's a wide question, so I don't think it has a specific answer that I believe everybody should rest on Sunday and others don't believe so, Commissioner.
I got the answer I was looking for, Judge. Thank you. And just to mention, I have received the documents you've subsequently submitted in respect to the wealth declarations that is now updated, and your clearance with the KRA, and yeah, basically those documents. And I think now you are compliant. Thank you very much. I wish you well. Thank you, Chair.
Thank you, Commissioner, and thank you for. In fact, I didn't have that the information from KRA, but I brought the wealth declaration forms. I worked in the public service. My belief is the documents in the public service don't decay. So they were retrieved from the JSC, and to JSC, I got them and I submitted. My wife's were retrieved from the Public Service Commission, and I submitted.
Okay. Thank you very much, Commissioner Onwade. Thank you, Honorable Judge. I think you had given us your county and also the ethnicities, so we'll not get there. Honorable Commissioners, we come to the end of the interview today, and we want to thank you, Judge, for coming back to talk to us. That is out of respect to the process. Unless you have something to tell us.
Thank you, Chair. Maybe I just wanted to refer to the question Justice Majanja asked me. Any two cases. I remember the community living in the forest is the Ogiek. I think there is the Ogiek case.
The Enderoy.
Okay. And it's good you know my background. I'd come with the intention of clearing one aspect of my life, and I don't know whether it would be prudent, I know, with the time, where the other time the commission asked me, having been charged, what do you think? But if it's not relevant, I don't have to belabor too much on it.
I think we can give you a minute to say what you wanted to say, Judge.
Thank you, Commissioner. You know, sometimes it's good when you have the opportunity to explain yourself. I joined the NSSF in September 2003, and by that time, NSSF had the task of complying with the Retirement Benefits Authority rules. It was skewed towards real estate, so it had to sell its property to reach the percentages required by the law. So by the time I joined, the board had resolved to sell some plots. So I was engaged in the selling of the plot opposite the Grand Regents. Those are 5 separate titles, 4 or 5. They were being sold at cost, 1,370,000,000. I remember they were advertised. A buyer came forth. I think there were 3 buyers, but some did not meet the minimum price. So this is a board which has resolved, and me and the managing trustee were doing the administrative work. So we received the 10% from the buyer, 137 million paid to NSSF, not to me. NSSF wanted to be sure that the money is there for the palace. We are talking of 1 billion in 2008. The money was put in the escrow account of both lawyers, NSSF lawyer and the buyer's lawyer. The NSSF lawyer was procured by the board, not by me, because there are anything to do with above 1 million. Even the managing trustee cannot appoint the advocate. By that time, you had to go to the legal committee and say there is this work. We have these lawyers in our panel. Whom do we give accountability? So we had to pay land rates. I went to the land office myself. It was computed 4 times, 112 million. Tried to negotiate, but it's every time it's computed, because of penalties, it came to that. So I advised my managing trustee, a banker's check was done. I personally went to National Bank, deposited that money. So the transaction went on well. Later on, because the buyer wants to know whether he's buying the correct thing, he sent a surveyor, and it was discovered that the land on the ground is lesser than on the titles. So that's where the problem came in. On the titles, it's 5 acres, but the physical aspect is around 4.5, slightly less by maybe a half or 3/4, like that. So the buyer asked if he could be given a pro rata reduction of the price. A meeting was done and we said no. So the land was transferred to the buyer. On paper, physically had not taken possession. And immediately it's transferred. The lawyer writes to our lawyer saying, I'm ready to release the money in the escrow account, less the pro rata reduction, revisiting the old issue. So NSSF told him no. We had other buyers. I think there was I was asking for less 130 million, something like that. So as the company secretary, we advised, we go to court, we went to court. I'm the one who was advising the lawyer, Mr. Oyatsi, preparing the documents, swearing in affidavits. We got orders to stay any further action. We are also in possession. There is no loss to the land, only the title had passed. I leave NSSF in April 2009. In June 2009, they record a consent in the case. By consent, the buyer has retracted, he takes his money, and NSSF takes its land. The same consent of June 2009 gives NSSF 30 million as cost. So nothing was lost. Come December 2009, you are arrested and you are charged. So that's what I wanted to share. One of the charges is that I conferred benefit to the government, paying the 112 million. But this was money which was demanded. A witness comes and says, I'm the one who did the computation, and without the land rent clearance certificates, we were not going to register this. So that is one count. Another count is paying the lawyer a deposit of 5 million in a transaction of 1.5 billion. And it's the board which approves the payment of a deposit. So you are charged for conferring a benefit to the advocate. So I just wanted, maybe people keep on saying there was embezzlement. There was no embezzlement. The money was in an escrow account. If I recollect, it was generating 7 million every month. And nobody removed a shilling from that account. I was not even a signatory to the account. And the owner took his money without a complaint. NSSF retained its land. It's there up to today. So that is just what I wanted to share. You know, some people think that maybe, I remember I had a tenant who refused to pay rent saying, see the pesa NSSF. You know, it gives you that negative feeling from other people, but that is what happened, and the record is there for all to see. Thank you for giving me this opportunity. At least I know it's not part of the interview, but I really appreciate it. Thank you, Madam Chair.
Thank you, Honorable Judge, and thank you for that clarification, and also for putting the record straight. And I'm sure the commissioners have had the position, and also the members of the public. So thank you once again, Judge, for coming, and wish you all the best.